גדי,
היי טל, מה קורה?
מה קורה? או-אה.
כן, זהו.
נסדר שנייה את הרקע. יותר נורמלי. תעבוד, אני לא רוצה להפריע לך.
מה? לא עובד.
הייתי עם מצלמה, אז חשבתי שאתה רוצה לעשות שמוזים.
לא, בדיוק קיבלתי הנחיות לגבי איסוף הילדה.
זה חשוב. נעמה.
היי, נעים לראות אותך.
הדדי. גדי, נעמה, תכירו.
אהלן, מה נשמע?
נעמה הצטרפה אלינו לאחרונה, כעמיתת מחקר.
נעים מאוד.
ברוכה הבאה.
תודה רבה.
קבוצה מגניבה.
כן, אני יום חשבתי. 5 בבוקר כאן, יש לי כוס ממש גדולה של קפה. כן.
סטארבקס סיאטל?
זהו, אני לא כל כך בעניין של סטארבקס, אני לא יודעת איך הכניסו אותי לפה.
האינטרנט, זה האינטרנט. פרי וי-פיי.
כן.
היי, בוקר טוב.
מה נשמע?
הנה עוד מישהי מהנכר בשעות לא שעות. Hello, we are in Israel.
רגע, אני לא שומעת כלום, שנייה.
We are in the peaceful Middle East, unlike a war-torn Europe. אין, אתם המשבליסטים נורא חצויים באירועים האלה. מצד אחד מלחמה נורא פשעים, מצד שני סוף כל סוף יש לכם משהו שמייצר אשכרה דינים קלאסיים שוב.
אתה יודע, היינו מעדיפים case study פחות אלים, אבל בוא נאמר, רוסיה מאתגרת את המערכת.
לא, תקשיב, אני זוכר שהיה את הכתבה על מתקפות סייבר שהתראיין איזה דוקטור למשפטים שמה, ועכשיו זה ממש אשכרה חצי קינטי, זה ממש...
אקטואלי, כן.
טלין 3 יוצא.
יובל?
היי, מה קורה?
בסדר, תכיר את נעמה דניאל.
היי נעמה.
היי, נעים מאוד.
מצטרפת אלינו למרות...
ברוכה הבאה, נעמה.
תודה רבה.
איפה את? באיזה חוף?
אני בסיאטל, חוף המערבי.
מערבי.
כן. בדיוק סיפרתי ש5 בבוקר כאן.
וואלה, כל הכבוד.
שוך.
ילד?
דפנה, היה לך את המפגש הזה? השולחן, מה זה היה? שולחן ארוחת בוקר? ה-Breakfast Club?
מה, ב-UFT?
כן.
היה על ה-Data Right, והיה סבבה.
טעים?
כאילו, היה מאוד, כן, היה טעים ומגוון. האמת שהפאנל היה נחמד, הייתה פטרה מולנר, היא ניו יורק, היא מתעסקת בכל מה שקשור ל-AI והגירה, פליטים. מאוד מעניין, דיברה על facial recognition. זהו.
טוב. נחכה דקה, טל, ונתחיל, ומי שיצטרף, יצטרף.
יובל, מזל טוב על הג'סאפ.
תודה, כל הצלחה היא המשך דרכך למעשה. היינו הפודסטפס.
אנחנו היינו כל כך רחוקים מלהגיע לא יודעת מה.
אתם, יובל לימד אותי the first cut is the deepest, אחרי שרוד סטוארט לימד אותו, אבל...
טוב, בואו נתחיל, אנחנו נתחיל בעברית נראה לי, כי כל הנוכחים כרגע הם, כשאני קלטתי בזווית העין, הם דוברי השפה, אבל אם יצטרפו אלינו סטודנטים או קולגים או פוסטים זרים, אנחנו נעבור לאנגלית.
אדוארדו הודיע שהוא לא יכול להצטרף היום, ואני יודע שמריה גם בלחץ, אז יש סיכוי שנשאר ככה.
בסדר.
בעיקרון נתתי לך גם שליטה על המצגת, יובל, אתה מוזמן לנסות את זה.
יופי.
היי אלעד.
טוב, אז תודה שאתם כאן, מי שכאן. הנה עוד דובר עברית הגיע. הפייפר הזה הוא פייפר שטל ואני כתבנו כפרק לספר שאסף לובין עורך ביחד עם ראסל ביוקן, ושעוסק בסוגיות של בעצם privacy ודאטה privacy, privacy ודאטה protection in times of armed conflict. זאת אומרת, השאלה היא בעצם לגבי הממשק הספציפי הזה, והנושא שאנחנו בחרנו לטפל בו הוא הנושא של בעצם שלב פיתוח אמצעי לחימה חדשים, שזה דבר שיש לנו קצת מיילג' בפדרמן, גם עסקנו בו בעבר. טיבו שהיה פוסט אצלנו בעצם כתב על זה, וגם יאלי כתב על זה, כשהפוקוס שלהם היה באופן ספציפי על הטכנולוגיה, על טכנולוגיה של Human Enhancement ודברים מסוג זה. המאמר הזה הוא בעצם שואל את השאלה ההפוכה, והיא איזה סוג של סטנדרטים צריך לבדוק כאשר בודקים טכנולוגיה חדשה ושוקלים האם להכניס אותה לשדה הקרב, לזירת המערכה, ובאופן ספציפי השאלה היא, וזה נגזר כמובן מהמנדט של הספר, הוא עד כמה שיקולים שקשורים לזכות לפרטיות יכולים להיכנס בתוך המסגרת המשפטית הקיימת היום להערכת החוקיות של אמצעי לחימה קיימים. עכשיו, הפרק מתמקד בשלושה אמצעים, זאת לא רשימה סגורה, אבל אלה הם שלושת הטכנולוגיות שנדמה לנו שהן נמצאות בחזית הדיון בנושאים האלה בשנים האחרונות. אפשר לשמוע ולחשוב גם על עוד טכנולוגיות. זה מכל מקרה, הטענה שלנו היא לא טענה... למה זה לבד בורח? ככה עשתה? אתה יכול להחזיר אחורה, שקופית אחורה?
כן, סליחה.
כן, אוטונומי, נכון. יפה, אשר. שנון מאוד. אז באמת שלושת הקטגוריות שאנחנו מטפלים בהן, וטל ירחיב לגביהם עוד מעט, הם הנושא של מערכות אוטונומיות, כמו אנחנו חשבנו בעיקר על שימוש בדרונס, ובאופן ספציפי השימוש שדרונס עושים בדאטה, בביג דאטה ובסנסורים בשביל לייצר מה שנקרא הפללה, זאת אומרת ליצור match בין מטרה לבין פעולה. המסגרת, הסוג השני של טכנולוגיות שאנחנו נדבר עליהן זה נושא בעצם military use of cyberspace, שבו בעצם יש אינטגרציה של מערכות קיברנטיות, גם במערכות הגנה, גם מערכות התקפה. אני חושב שרוצים לעבור לאנגלית, לא? And the third category will be human enhancement of soldiers, which is something that we have, as I said before, we have worked on in the Federal Cybersecurity Center. And in that context, we are talking about technologies that have a number of features, but maybe the most interesting features for us would be human-machine interfaces. So that we have systems by which machines are able to convey data to human brains and vice versa. And perhaps also each system is able to issue orders to the other system. So these are the type of technologies that we were thinking about that may have privacy implications. What is interesting about these technologies is, yes, they have privacy. They may have privacy implications. They raise difficult human rights issues, including privacy issues. I think privacy, and we were asked before when we presented this paper in another seminar, why are we focusing on privacy? And I mean, the short story is, of course, we were asked to write a paper on privacy, so we are focusing on privacy because this is a book, and that's the nature of book chapters. But in truth, I think there is also perhaps a broader issue, and that is that there are some rights within human rights law, such as the right to life, which is generally also paralleled in IHLs. So you also have a lot of contents within the laws of armed conflict or IHL that covers the same human rights, or maybe you have multiple layers of protection. But privacy is one of these rights that really exists principally within the framework of human rights law, and it is quite hard to find parallels within IHL. There are very specific parallels in a number of provisions, but they are thinking really more about physical space, about the home, and about sexual offenses and the like. So these are the issues that are raised within IHL. Now, the technologies that we are dealing with, another important issue that they are, by essence, we are talking about dual use technologies. I mean, these technologies have not developed necessarily specifically for military purposes, or not completely for military purposes. And this is, I think, an interesting aspect of the issue at hand, because it means that it's not really feasible, and it's not really likely that the technology itself would be curtailed by what we are proposing. It's really the specific application of the technology to military context, which is at stake. So AI machines, they're out there, they're driving the streets. Yesterday, the Knesset passed a law which authorizes autonomous vehicles to travel the street, to basically blend in men operated traffic. Drones are used in other contexts. We are concerned about the military application. Same goes for cybersecurity, of course, which is not just, occurs all the time outside armed conflict, the use of cyberspace for better or worse purposes. And also human enhancement, man-machine interface is not something which is specifically created for military purposes. Actually, so far the most impressive and important applications of such technology were therapeutical. So it's basically to assist persons with mobility issues to basically have an ability to command their environment, to command the vehicle they're traveling, or to control a computer, and to, through that, basically utilize their brain power instead of their ability to mobilize. So that's so these are the sets of issues that we are dealing with, and the focal question that we are asking in this paper is really whether Article 36 of AP1 of Additional Protocol 1 is an appropriate framework to be asking questions about the privacy implications of introducing these new digital technology applications to military contexts. So maybe we can say a few words about AP1. So those of you who have not worked recently in IHL, basically, very quickly, of course, this is unfortunately now very relevant in a more physical and immediate sense, although there are also issues relating to cyber warfare in the Ukraine context as well. But when we are talking about yeah, so it's a buy one get one system. You press one button and then you get 2 slides. Move forward. That's very good. So IHL, essentially, one of the important features of IHL is that it, other than regulate the conduct of parties to a conflict by indicating what targets are lawful and what targets are impermissible, there is also a general attempt to, there is a concern about weapons, means, and methods of warfare. Their choice is not unlimited. This is the language of 35.1 of AP1. And the implication is that the certain weapons, certain means of warfare, certain methods of warfare cannot be used in times of an armed conflict. And essentially, when we are trying to ask ourselves, okay, so which weapons, means, and methods cannot be used, the answer would then be divided into two sets of answers. There are specific bans on specific weapons, means, and methods. And therefore, there are, for instance, treaties that ban the use of chemical weapons. Okay, so chemical weapons are a banned weapon. You cannot use a chemical weapon during an armed conflict. There are also limits on specific means and methods. So certain methods of espionage or would be regarded as impermissible if they invite the trust of, illegitimately invite the trust of the other party. And then you have general principles which are applicable to all weapons, means, and methods of warfare, and they represent another set of limitations. So sometimes there is a specific ban on a specific weapon or means or methods, but sometimes there is a general ban, a general norm which all weapons, all means, and all methods need to comply with. And I've not listed here everything, but 2 perhaps representative and quite important bans that you can identify, general principles that from which you can derive a ban. In certain cases would be the prohibition on employing weapons, projectiles, and materials and methods of warfare of a nature to cause superfluous injury or unnecessary suffering. This is sometimes we call the Cyrus principle, which limits certain the use of certain weapons, etc. And there is also, since there is a principle of distinction in IHL, which is indicated here in Article 48 of AP1, there would also be limits on using weapons, means, and methods that are incapable of drawing distinctions, at least in certain terrains. So for instance, in the recent war, we're already hearing concerns about use of cluster munition in terms of in cities, in populated cities. And although Russia is not a party to the cluster munition treaty, so it's not subject to the specific ban, there would be a question as to whether the general provision of Article 48 is applicable. Now, these are what you could say, these are the primary norms which indicate which methods, means, which weapons, means, and methods could be used and could not be used. But then there is a procedural norm which basically governs the decision-making process as to whether or not to use such weapons, means, and methods. And this is found in Article 36 of AP1, which is the obligation to conduct a legality review. So this is again an additional protocol 1 norm, and if you can see, I mean, if you can read, you can see the language here. It's quite broad in its scope. It talks about the duty of a high contracting party. So these are parties to AP1. To determine whether employment would, in some or all circumstances, be prohibited by this protocol. And in terms of when do you have to invoke this, the protocol takes a broad approach and talks about the study, the development, the acquisition, or adoption of a new weapon means or method. So when we are looking at how this has been understood in the commentaries and also in different, a little bit in practice and in ICRC position statements, you can see that, go back one slide, please. This provision has been understood as applicable not only with regard to weapons that have been developed by the party, but also weapons which have been developed by a third party. So it could be, if I am a state and I'm purchasing, let's say, an autonomous weapon system from a private company or from a foreign state, I will be nonetheless required to run an Article 36 review before I'm actually introducing this system into my military. Another important notion is that this is an obligation that, unlike many obligations of IHL that kick in when the conflict begins, the obligations under Article 36 are ongoing obligations. They are more infrastructural in nature, like obligations to train soldiers in IHL. So these would be obligations that would apply both in times of peace and times of war. So whenever a military is contemplating, developing, acquiring, introducing a new weapon or method or means, they would have to basically resort to an Article 36 evaluation. The ICRC has taken the position, which I think makes sense, that the obligation under Article 36 is not a one-off obligation. Namely, that if we have information about the actual application of a certain weapon system, which raises issues, raises concerns about its compatibility with the obligations of the state, or maybe because a new norm has been generated, then there would be a requirement to run a new Article 36 review. This is at least one possible interpretation of the obligation. In terms of applicability, as I said before, it's applied to weapons, means, and methods. I mean, we don't have to go into a lot of hair splitting as to what is a weapon, what is a means, what is a method, but maybe very quickly, we are using in the article like the standard ICRC definitions of what is a weapon, either a system which can be offensive or defensive. We are talking about means as basically the additional, the supplementary measures, the supplementary activities that are designed to facilitate the use of weapons. So for instance, if the weapon is a drone, the data collection would be the means that would then facilitate the drones, and the methods would be the different strategies by which one deploys weapons and one deploys means. So we are talking about 3 different levels of military activity: the actual use of harmful means, the supplementary use of means which are designed to facilitate the use of harmful means, and the methods of actually deploying, bringing yourself to a position where you can actually deploy either weapons or means. There is an interesting issue which is raised in the literature. I think that would perhaps justify a separate article. So we have not really, we've dealt with this very briefly, but I think it's an interesting point. And that is the issue of scientific uncertainty, which is of course very relevant here as well. We know that in some fields of law and policy, when one has environmental law is perhaps a clear example. When one has one is confronted with uncertainty about the state of the potential impact of using a certain method or certain means, certain technology, then there would be legal principles that would regulate the decision whether to introduce or not, whether to assume the risk or not, like the precautionary principle, which one finds in environmental law. It's less than clear whether this principle applies fully in IHL. Let me put it at this point with this, but there would be areas, for instance, involving the environment, and IHL also regulates weaponry, means and methods that can cause an environmental harm, where one could make the argument that this would be an issue. And I think, again, the news coming from Ukraine about what's happening in and around the nuclear reactors, I think give us a lot of reason to believe that a precautionary principle would be appropriate, at least in certain contexts. Now, in terms of going forward, Tal, are you able to push it forward? Yeah, I think I have only 2 more slides and then Tal takes over. In terms of going forward, one immediate question that we need to address is, okay, this is AP1, but what does one do if one is not a member of AP1? And many countries, of course, are not members of AP1. Many countries with, at least in many small democracies in the Middle East are not parties to AP1, and also at least one large big democracy in North America is not a party. But there are other countries, important countries who are not, in terms of military activity, that are not parties to AP1. The question is whether they're obligated anyway to run these sort of reviews, and the answer is probably yes, because these reviews could be justified by, they could be understood as really as derivatives from the substantive obligations that the parties have. So if you are required not to violate the principle of distinction, it's a reasonable interpretation of your obligation, and you're also required to take precautions in order not to violate the principle of distinction. It only makes sense that before you introduce a new form of weapon, you would basically apply your mind to the question as to whether the weapon is likely or not to put you in a violation of your obligation, substantive obligations under IHL. So I think a case could be made that even if you do not have, even if you are not bound by Article 36, you have to do an Article 36-like evaluation in order to be in a position to meet your substantive obligations. And we have seen that states who are not party to the to AP1 have not contested their obligation to run legality reviews. I should also say that Article 36 doesn't really set a very specific procedures. So states, whether they are bound or not bound by Article 36, they will have a lot of latitude as to what they are doing, but they are required, we would argue, to have an IHL, under IHL, they would be required to have, they would have to run a legality review. But of course, when you move further from IHL, I think you would also find the same kind of thinking also applicable from other legal norms that are relevant, and that's specifically human rights law. So human rights law is generally considered applicable also in times of armed conflict, acknowledging that Israel has not accepted this point fully and formally, but it's somewhat semi-isolated on this issue. I think all other countries now have accepted this, the co-application of human rights in IHL. And if you look, for instance, at a statement of human rights law from 2018, this is General Comment 36 of the Human Rights Committee. I sat on the committee then, so I have to acknowledge some responsibility for the text. But you could see that the kind of thinking about the substantive obligations driving or introducing also some procedural requirements of based on some idea of precaution. They also apply here. So for instance, the Human Rights Committee specifically on autonomous weapon systems said as well, these autonomous weapon systems raise difficult legal and ethical questions concerning the right to life. And the committee is therefore of the view that such weapon systems should not be developed and put into operation either in times of war and peace, unless it has been established that their use conforms with Article 6 and other relevant norms of international law. So it's this idea about you have to do a legality review before you are going down that path of introducing autonomous weapon systems. And that is this kind of, although the number 36 appears here, it's pure coincidence. There is nothing which connects this to Article 36 of AP1. So I think that's a strong authority, both for the general applicability of the reviews, but also of the fact that it applies independently. The requirement applies independently from human rights law, also besides IHL. I think I do have one more slide, and that is that in terms of the scope of the legality review. And that is, and then Tal takes over. Clearly IHL is implicated, and IHL also contains the famous or infamous Martin's Clause, which is this general provision that allows decision makers, when there are lacunas in the law, to address them through inter alia, appealing to principles of humanity and dictates of public consciousness. So there is an ethical dimension here, which could also be introduced into IHL through this Martin's Clause on some issues that are not regulated. Of course, on weaponry, there would always be disagreements as to whether the fact that the weapon has not been outlawed, what does it mean? Does it mean that the weapon is if it's not outlawed, then it's legal, or whether we have a lacunas? So I'm not going to go there. This is an interesting IHL issue, but not now. But importantly, Article 36 of AP1 also alludes to any other rule of international law applicable to the high contracting party. So the text of Article 36 itself has a renvoi provision. It refers to other sources of law, which would of course include human rights law, and we argue in the paper that it includes the right to privacy under human rights law, which with respect to these three technologies and maybe others is quite relevant, since these technologies are data intensive. They assume access to computer systems, and once you access a computer system, there is a lot of personal information that can be gleaned from that. And they are also premised on some interconnectedness of data and devices, which again allows, if these interconnectedness go too far or are hacked, then many privacy issues would be raised. So this is part 1, 2, and 2 of the article. part 3 and 4 actually try to apply this with respect to the 3 weapons or means and methods that we have identified, and I pass it on now to Tal to take it from there.
So thank you very much, Yuval, especially for the patience with the presentation. Every time we entered someone to the meeting, then another slide went through. That was the technological explanation.
That's dual use technology as well.
Dual use click. So I will shortly highlight or flag some of the privacy concerns that we have found in relation to those 3 technologies, and we will be very happy to hear, first of all, if any of you thinks that other technologies are also relevant for the discussion, and specifically if there are additional aspects within each of those 3 technologies that we did choose that also deserve better attention. So the first technology is the autonomous weapon systems, and while at first glance one might say that, well, what does a rifle, a gun, or a plane shooting from the sky have to do with privacy? First of all, we will clarify that when we discuss privacy, it is broader than the classic narrow understanding of the right to be left alone. Rather, privacy, to our understanding, also includes or also entails within it the importance of protection of core aspects of human dignity and also physical and mental wellness. And in addition, the link or interconnectedness between the right to privacy to the fulfillment of other rights as well. When it comes to autonomous weapon systems, now I will try to admit someone to the meeting without moving. Okay. So in relation to autonomous weapon systems, while those systems basically try to replace humans in decision-making in relation to targeting, in order for those systems to replace humans, they need to rely on data, and quite a lot. So in order to deploy an effective, for example, drone program, surveillance and flow of data is needed as part of the decision-making progress. So we mentioned in the article the drone program of the US in Pakistan and their patterns of life program, which basically attempted to recognize patterns of life of people which are involved in terrorist activities and make decisions based on it. So putting aside ethical and legal questions which the use of autonomous weapon systems raise in the context of IHL, like distinction, proportionality, and etc., it has been recognized, for example, by human rights committees, that UN human rights committees, that the continuous surveillance required for a drone program and the constant hum of drones themselves constitute in and of itself a violation of privacy. Hence, it has some bearing in this regard. In addition, the fact that there is flow of data which is required for the decision making also indicates that maybe some data will be transferred to other systems, to other departments of the military or security forces, and there can also be privacy risks which are associated with that data. But at the end of the day, we recognize that this is more minor in comparison to the other 2 technologies we discussed. So the second technology we discuss is the military use of cyberspace. Now, until recently, we had very few examples to discuss. For example, in order to demonstrate the military aspect or the military use of cyber attacks, one would have turned to Stuxnet or one of the main other very specific examples. But recently, sadly, Ukraine served as a test lab for Russia to attempt to improve their cyber capabilities. And this test lab was, at the end of the day, a preparation for a full-fledged military conflict, which we are now witnessing. Now, Russia's cyber capabilities are vast in quantity, but not so impressive in quality when compared to semantic or synthetic attacks. But nevertheless, they definitely can create, they definitely can affect the situation in reality, and their attacks are usually one of two. Their two main modus operandi are one of two. So it's DDoS to crash a site, and also wipers. So when it comes to wipers, for example, then it definitely has bearing on data. And when they simply want to steal data, it also, of course, can include data which enjoys protection under privacy. An example of a data which is found, which includes both military and civil interests, is the Office of Personnel Management attack against the United States in 2014. So it is reasonable to assume that that attack was based on military interest, but at the end of the day, some of the information that was stolen is definitely falling within the private sphere and raises considerations of privacy. In addition, another problem is the problem of spillover. So again, from the Russia-Ukraine context, we can think of, for example, the NotPetya malware, which was directed against Ukraine, their tax authorities, but then spread around the world, including against Russia. So the spillover effect raises questions mostly in relation to proportionality, because even if we can justify some infringement of privacy for a very specific tailor-made cyber attack, given spillover effects, at times, even if we can justify, for example, a legitimate aim for the restriction of privacy, nevertheless, we will have problems proportionality-wise. Now, there are also programs of mass surveillance. For example, those which were discovered as part of the Snowden affair, but those are usually occurring during peacetime, so they don't fall under the ambit of Article 36. Nevertheless, when they are deployed during armed conflict or in the context of armed conflict, they definitely have some bearing or importance. Now, we think that in this field especially, the need to re-examine every now and then the technology arises most evidently or most pertinently, given the jumps in the quantum leaps in the abilities of conducting hostile cyber operations. One last point in this regard is that we are focusing on dual use technologies, and we think that the cyberspace presents the biggest dual use difficulty, because when we discuss, for example, prosthetic enhancement for soldiers or for civilians, then it is quite easy to differentiate between a prosthetic which is used for a person who was injured by a car accident or a soldier. But when it comes to cyberspace, then we have satellites which can serve both the military and civil sphere, which can help us activate Waze and etc., but also direct tanks on their way to Kiev. So this is a very big difficulty in the consideration and application of IHL to cyberspace. As for the third and last technology, here we were very happy to first of all build upon the great work of our friends Yali and Thibaut. And here we discussed the most three common forms of enhancement: biochemical enhancement, namely pharmaceutical tools, which are used to either deal with mental or physical issues which interfere the soldier within its duty. Prosthetic enhancement, as was discussed earlier by Yuval, and cybernetic enhancement. Now, out of those three fields, it is obvious that when it comes to cybernetic enhancement, namely embedding cybernetic systems within a soldier or creating some form of duality between the brain and an external system, is the type which raises most concern. One of the main concerns here is the issue of consent. How do we examine prior consent? How do we know that the consent was informed? And how can you even envision what your consent will encapsulate when you agree to something like that to begin with, putting aside the issue that soldiers' consent is limited to begin with, as he is part of a system and he aims to please the system within which he operates. Another issue which arises is that if, for example, the cybernetic enhancement will include cameras, either cameras which show what the soldier is seeing or cameras which look inside the systems within the body of the soldier, then there is an important need to consider how to turn off those systems from time to time. For example, when the soldier goes to rest in between battles, or when the soldier goes to the bathroom. Now, the right to privacy mainly protects a person within his home, but home is also a very broad concept. And when we deal with a soldier which is deployed in a tour, for example, 3 months in Iraq or Afghanistan, then his residence place is his home. So when he's off duty, there is a need to mitigate the infringement into his privacy, so long there is no operational justification to do so. The last issue that I will mention is that we need to think, what do we do on the day after the retirement of the soldier? In Israel, we are used to a short chapter of several years and then reserve duty. So how will that model work? If someone will undergo enhancement during his regular military service, will it have impact on his civilian life? How will he be able to continue civilian life? And will he have a requirement to go back and serve in reserve duty? So these are issues which are hard to envision without seeing how this unfolds in practice. I will add 2 small points. The first is another concern is, of course, concern of hacking into the systems of the soldier, which is something that can be envisioned. And the second one I will discuss as part of the general conclusion. And I will also take a step back and not only talk about enhanced soldiers. There is a difficulty in measuring the specific harm to privacy, as these new technologies reveal or illustrate new forms or new challenges to human dignity, to what we understand as mental and physical well-being. And there is a serious question, how should we measure it? So Yuval mentioned earlier the Cyrus project by the ICRC. So in that project, a main idea was to use interdisciplinary knowledge. So expert in weapons, expert in health, experts in law, and etc., all set together and try to understand how to evaluate better the impact of weapons in general. So we suggest that a similar process will be done in relation to those new technologies, that there will be some form of privacy impact assessment with measurable tools. And in addition, that there will be a need to re-examine it from time to time, because even if, for example, we will be able to come up with a definition of consent which is acceptable and becomes universally objective understanding, what happens when someone regrets their decision or the prior consent which he gave? A soldier can agree to something today and then regret it in a few years. And then the state, the army or the security force is invested within that soldier. And if, for example, there is a need to do updates to a system which is embedded within the soldier, what real leeway of discretion does the soldier have? So Yuval and I try to basically highlight most of the policy and practical questions which we found as relevant. We were limited by the fact that we are dealing here with a book chapter which is limited in words and in the ability to expand on some of the aspects. But we will be very happy to hear from you. First and foremost, if there is anything else you think that should be added to this mostly descriptive presentation, but also with some normative flagging statements. And also, where do you think that the most focus should be given in future projects that will continue this one? So thank you very much for listening, and we will open up the floor for discussion. So first and foremost,
Yali.
our expert for human enhancement, Yali.
Not exaggerate. Okay. Thanks. It was really interesting, and I have, I think, 3 questions. The first is the privacy concerns when it comes to enhanced soldiers are mostly about the soldiers themselves. And how do you apply IHL to this issue, since in most cases IHL applies to concerns regarding the adversary? I understand how human rights will work here, but at least when it comes to weapons review and so on, I wonder doctrinally, how do you explain the application of IHL in this issue? Second, you mentioned at the end the ICRC project about weapons, and you didn't say anything about the fact that it was a huge failure. And you suggest to build from this project some kind of scale to assess privacy concerns, but they failed tremendously when it came to measurement of suffering. So I'm not sure that it's a great idea. And third, maybe it's not. Well, I wonder why do you focus on Article 36? I'm not aware of the huge success over the years of these processes. So if you're interested in limiting weapons, at least from the way that I see it, there are 2 main options. One is having a specific convention with a prohibition on certain weapons, or focusing on discussions about the legality of the use of these weapons. I'm not aware, maybe I'm missing something, but I'm not familiar with many types of weapons that were prohibited through AP 136 processes. So I wonder why did you choose to focus on this issue? Maybe it was the direction of the editors, but I wonder why do you think that this is a path that should be taken when it comes to privacy concerns?
You want to start, Yuval?
Yeah, maybe. Thank you, Yali. Good questions, as usual. On the privacy to soldiers, I think you're right. I mean, I think it would be very hard to establish under IHL an obligation. This is why we thought human rights law is really the way to go with the enhanced soldiers. The question would still be what is the basis for considering human rights law? And you have 2 bases. One is human rights law itself. So the same paragraph that I've read on General Comment 36 with regard to the right to life could apply with some modifications also to right to privacy. But also Article 36 of AP1 is also in a way an anchor on which it's a hook on which you can hang also the right to privacy of the soldiers under human rights law. So the claim is not that this is, you may make a claim about, torture, cruel human treatment. I mean, that's, and Thibault has written in that regard. But then you, of course, get to the difficult issue of what the state owes its own soldiers, etc. So human rights law is a much safer way to go. On Cyrus being a failure, yes, it's been a failure, but it's been a spectacular failure. It generated a lot of information. It generated a lot of attention. Ultimately, failure was partly because maybe the research question was indeed too morbid. I mean, how can you rank? Because you do have this problem when you're ranking pain as to whether this is an objective or subjective standard, and I think it was very hard for the Cyrus project to get over this. I think with regard to privacy, in a way, there are some, you may have more to work on because you have a lot of rich case law within domestic legal systems as to what constitutes a violation of privacy. So this is something you may be able to build on. But I don't pretend that this is going to be easy. It's going to be probably difficult. Tal, do you want to take the Article 36 point?
I will just mention, Yali, that first and foremost, IHL is evolving like any system of law, and just in the same fashion that the ICTY, for example, used provisions which were supposed to protect adversary soldiers, to protect soldiers coming from within the same state. I think that the law can evolve in a way that will include protection of your own soldiers. As for Cyrus, I will only add that you must build, I think that building on failure is sometimes the best way to move forward. And we take away the two good things from Cyrus, which the first is the interdisciplinary approach, which is required when it comes to new technologies. And the second one is that we need to add some, there needs to be some measurability of harm to privacy, because usually under Article 36, you don't measure privacy, right? You measure distinction, you measure proportionality, you measure other more classic rules of international humanitarian law. So we are suggesting an innovation, and at the same time, we recognize that there needs to be more innovation, namely naming measurability of privacy in order to actually make it work. As for your last question, I think that Article 36 is basically the best avenue or the only avenue for an ex-ante examination. The two avenues which you mentioned, either drafting a treaty or examining the legality of the use of a certain weapon. So drafting a treaty requires for a weapon to be internationally recognized. For example, the optional protocol dealing with blinding laser weapons was only possible after such weapons were entered into use. And we are talking about evaluation before they're able to enter into use. And as for the examination of the legality of the use, then it's even a more later stage down the line. So the idea is to add another stage before those two. So it's not instead of the two most common avenues, which you are absolutely correct when you mention them, it's to add another step before them.
Maybe I could just add that on lethal autonomous weapons, you do have a very developed conversation about the moratorium, and I think there is a strong sense that they should not be introduced before you have gone through a kind of legality review. And although Article 36 is not always mentioned in this regard, I think Tal is right that this is the only black letter law provision that we have that actually mandates these sort of reviews. So I think it is a natural way to start. And militaries are actually, I mean, we haven't looked at this empirically, but militaries are claiming that they are complying with Article 36, including the US military, which is not party to the AP1. So I think it does seem like a convenient point of departure. Tomer?
Yeah, thank you. So it's super interesting. Thank you for the presentation. And I'm mainly interested in the role of the dual use concept inside this project and in general in the testing the legality of a new weapon. And I think it's interesting because the use and the reliance on data, personal data and big personal data is start in the army, in the military, and then in recent years become like more standard a method in other contexts. So I wonder what will happen to privacy after if we integrate a privacy into the measuring the legality of weapon, because in the one hand it can be really interesting because if we will say that also in military uses, we have those problem of privacy, then of course we will have it when it become more in other application. But the privacy inside this circumstances would be different than privacy in other circumstances. So I'm wondering in general, I'm asking actually, and I want to know what is the rule of the dual use here? What does it does to this testing? And another question is, in other contexts, and what is, if there is like the principle of distinction, is have application also not just in life and death questions, but in other contexts, because I think it's super central here, because we can say, okay, we can have very personal data of some of the military people, but not of the civilian. So I'm wondering whether the distinction is whether to harm people or also with the question of the means that you raise here. Okay, that's for now. Thank you.
Okay, just to make sure, I mean, dual use, of course, we were using it in a somewhat colloquial sense. I mean, when we normally talk in an IHL context of dual use objects, we are talking about an object itself that does play a role in making an active contribution to the military effort, but also having a civilian role. I think this.
Can you give other example to dual use, not from the tech side?
Oh, a bridge is a dual use object. Okay, a civilian bridge, because civilians cross the bridge, but also tanks can cross the bridge. So
okay, but it's the same object, not the same.
But it's the same object.
Yeah.
Okay, so here we're talking about dual use technology, and this is a term which is also used, of course, in other contexts about limits, about the export limits and such. But within IHL, I just wanted to highlight that what we are saying is different. So I think that the point you're making is a very interesting point, because I think that if we reach the conclusion that even in times of conflict, right, using certain technology would be unacceptable because it goes too far in violating privacy. And in terms of the military value, it would be marginal. I think it would be hard to justify the use of the same technology outside a war context. And I think this is a specific issue that is raised with regard to to police drones. I mean, I think there is already some discussion as to whether law enforcement should be using drones for policing. And I think that the argument, and also
policing.
Yeah, but yeah, I mean, I think Pegasus within a military context would be easier to justify, because I think that within a military context, I mean, this is military intelligence, they're in the business of
and then the question of distinction is,
okay, yeah, but for your first question, I mean, I think there's a general presumption that in military context, there would be a strong necessity justification for limiting rights. So if something does not meet that strong necessity justification, even in a military context, it would be harder, you know, to apply this in a civilian context, unless you can develop in a civilian context a different justification. Or unless you identify, and that sometimes happens, you identify within IHL a specific rule that applies only in IHL and does not apply in a civilian context. One clear example would be the use of tear gas, which is prohibited in IHL because it's seen as a chemical weapon, but it's not prohibited in law enforcement. So you could have that as well. Now, the principle of distinction, this is a very interesting issue. I would say that this does not actually fall under a conventional understanding of the principle of distinction. The principle of distinction has been developed in the context of targeting with weapons. Okay, you need to have a very, I think, imaginative understanding of data collection as a form of weapon. I think that is
means or method.
Yeah. But even with regard to means, the principle of distinction is relevant to targeting decisions. Okay, so now there are other issues. There are prohibitions on collective punishments in certain contexts. So I would say that a proportionality analysis, okay, within human rights law as applicable in times of armed conflicts would be appropriate here, okay? But I don't think, maybe Tal thinks differently, but I don't think you can just cut and paste the principle of distinction that has been developed with regard to targeting and apply here, and also at least the state practice, I mean, the use of patterns of life. It really is very difficult to use big data for intelligence and operational purposes unless you collect a lot of data of people who are not involved, because you need to somehow distinguish the militants from the civilians, and for that you need also information on the civilians. So I think it's so in a way I have doubts whether a rigid principle of distinction which says you can only collect information on. Where this could apply is in other places such as data retention. Okay, so there could be important distinctions about whether you can keep information after the war is ended about enemy civilians, maybe as opposed to about enemy soldiers. But this is my
maybe
initial
obligation for anonymization of the data of the civilian that not the target.
But this would be human rights privacy law, you know, basically these arguments you would have to make under human rights privacy law, and the fact that this is a conflict are not only maybe is relevant to the justification, you know, to the strength of the justification that you have for violating a right to privacy. Tal, what do you think?
Yeah, I agree. I would just add that maybe the closest example we can look at to understand how to apply distinction may be in relation to the dual use target of communication centers, communication buildings. So, for example, the RTS building in Serbia, when NATO bombed it, it had two main reasonings. So the first was tactical, that there was military use in the networks and etc. And the second was more strategic. So the only way to try and so I think that if we will be pushed with our backs against the wall and then have to choose one, then it must be the narrow approach, namely only tactical considerations, because applying strategic considerations will devoid the rule of any effectiveness. So that's the closest thing I can think of. And I absolutely agree with Tomer's suggestion about handling, how we should handle the data. And for that, we suggested maybe the use of some privacy protocols or guidelines on how to use data after it is collected for the use of the very specific target. But I agree, it's a very challenging question. And the more challenging it is, the more interesting it will be to try to answer it. So maybe that's the next thing to tackle. Thanks for the idea. Amit?
Hi everybody. Thanks really again, a very interesting, a very important issue. I'll apologize in advance, always in this forum in which a political scientist needs to ask the questions of a bunch of lawyers and legal scholars, then I'm always trying to stretch the borders of the horizon of the talk. So maybe my questions will serve you for your purpose to expand the research. So two short ones. I was wondering whether you also would extend, or did you already address, you know, the changes in the Wasserman agreement, dealing with dual use and arms control dual use. Objects and artifacts seems to me, specifically, I personally know, of course, on changes that regard cybersecurity or the use of computers, which really touched that, but this also addresses other stuff, and I was wondering whether you explore that as well. And the second question addresses the growing, number of, I would say, suggestions on international initiatives which are about policy by design, trying to already think of, and I know privacy is a major issue there, as well as bias of different kinds, specifically in regards to AI. I was wondering whether those initiatives, whether done by states or NGOs, were in a way implementing some of the things you were investigated, and whether this is actually, all those areas are actually important nodes of effects in which you should investigate when tackling such an important issue, which is a bit, well, of course, it's a bit out of the scope of this like specific, international law, legal texts. Thanks. And well, apologies that I have to bounce off the meeting in a couple of minutes because I have a receiving hour.
Tal, you want to start maybe?
First of all, Amit, it is very helpful that you are pushing our boundaries and expanding our thinking. So thank you for that. I think that absolutely any tool which guides us in better implementing or integrating privacy considerations in the evaluation of those new technologies is helpful. And I refer to both avenues which you suggest. The main problem is, of course, that when it comes to new technologies that serve for military purposes, privacy seems to receive less attention or less importance. So in the same fashion that currently in the Russia-Ukraine context, anyone who will try to talk about a cyber risk will be canceled because people are dying now and more important things are happening. So it is a challenge to boost up privacy concern within this ecosystem, to use your language. So we think it's a challenge which is worth taking, and we will take both of your options, both avenues suggested, and use them to amplify this message. And I thank you for that. That's very helpful, actually.
Yeah, I'll just briefly, Wassenaar, of course, is a very different framework that deals with exports. So we were talking about the duty of in the way of the receiving state, not of the exporting state. But I think that's an interesting point. I mean, I'm not aware of introduction of privacy protocols in Wassenaar, but I saw that in recently vis-a-vis Hong Kong, there have been concerns about use of basically policing and law enforcement equipment that could be used also for human rights violations. But we may have to look again and to see whether there have been issues relating to hacking or something like that, which could be used as in this regard. Normally, the concern is opposite. I mean, there is a development of something which would be fine in a civil context, but then there would be an abuse in a military if it would be then militarized. So we will have to see whether it applies. And on the NGOs, I think that's a great point. And as I responded to Yali, I mean, NGOs have been really at the forefront, at least on the lethal autonomous weapons issues. They've been really driving the process and calling for the moratorium, etc. So in a way, they are the background to the reason why these discussions are taking place now in many fora, global fora.
Yuval, Wassenaar specifically speaks about intrusion software and a bunch of other terms which might be very relevant. Look it up. I mean, and it's been there for a while, and there's a bunch of perceptions and actions done by states involved. I think it's very relevant, especially intrusion software, which is specifically mentioned there.
Okay, we'll do that.
No?
Hi, I'm sorry for the background noise. I have two kids here. Okay, so great paper, very interesting topic. I agree with Yali on his comments regarding kind of the consumer mix. I mean, that it's aimed to, Article 36 is aimed to protect on the population or the target, and the soldiers are protected under National Human Rights Law. But I have two additional questions. The first is the difference between privacy infringement of mass population or specific individuals. Do you think it has an effect through the lens of Article 36, because I think that in human rights law, it's kind of the other way around. What I mean is that, for example, geolocation, the more it's more massive, more general, the privacy infringement, I think today is weaker than when it is precise and targeted to a specific individual. So I'm just curious to hear your thought about it. And the other point, and I apologize in advance on my limited knowledge in IHL. When you include privacy as a consideration under Article 36 of the additional protocol, can it extend the definition of or impact on the definition of use of force, or it doesn't work this way? What I mean is, if you hack a phone, if Israel hacks you mentioned previously NSO of a foreign individual in other states, and now that you think of privacy as an element in and of itself, does it have any effect in this regard? Will we look on it differently?
Yeah, maybe I'll start with the second, and Tal could take the first. So I think there is a growing openness within IHL to think about reverberating harms. So to think not only about the immediate harms that are caused by military attacks, but also on long-term issues such as distress, such as mental harm, distress, in terms of long-lasting repercussions on quality of life, health, etc. So I think once you introduce a concept of privacy harms into the analysis, I think this could become part of the calculus in actually assessing legality of activities under IHL or duties to compensate or what have you. We mentioned in the chapter this idea about the drones in Waziristan, Pakistan, making basically affecting the mental well-being of residents, knowing that they are constantly monitored and hearing the hum of the drone all the time, not knowing when it's going to strike. This is something, so this is not just an abstract privacy concern, but it's really a very conspicuous, maybe, intrusion in which has also, of course, privacy dimension. So I think it is an point. I wouldn't say that all states or most states are on board on this. This is more stuff you see ICRCs pushing this agenda, some experts and academics. We haven't seen so far a lot of momentum on the side of states, which is a general issue about IHL and how it's been created. And Yali has written on that and why the process through states is stuck, and therefore you have to develop all sorts of other channels. And human rights, in a way, is one of these channels of fleshing out all these costs of war that the traditional norms have failed to capture.
So I will just add, first of all, that's a great question which you raise, the FNA in relation to an individual versus a community. And I think that that's a challenge that cuts through most human rights. In most human rights, you will have a very different perspective or understanding of the right when we're dealing with an individual or a community, and that's a very important perspective that we need to consider. So thank you for that. I will say, however, that geo-blocking has several aspects. So you're absolutely correct that when we look, for example, at surveillance, then the tailored suit will be will infringe less on the human right. But if we look, for example, at other human rights, for example, freedom of expression, if I'm suspending someone's Facebook account, well, in fact, I can actually limit or limit the infringement in his right by geo-blocking. So it's actually something which I think that any discussion of human rights and technology with an extraterritorial dimension, which happens in most cases in cyberspace, must include this discussion. So I definitely think we must have we must add a statement in this regard, and we will have to think better about how to address it specifically, but that's a very important angle. Yuval, you want to add something?
No, I mean, is this what you had in mind, Daphne, or are you talking about
Yes, but now that
specific individuals, because Tal talked about specific territory.
Right. No, my question was general. How do you see if there is an impact when it's on a whole population or massive population, and less and versus like specific individual targeting? But now when Tal raised his last point, I have another question, if I may. Privacy is an important element, but still, when you look on IHL in general, it's still marginal when you think about the rights that you might infringe in this regard. And I wonder, I mean, when we think about other rights as well, is there any like kind of a cutoff that we can think of? For example, when you displace the population, you also infringe their right to education. Okay, but you don't really regard it. It's not like the main issue. So what makes privacy here, except for the need to be part of these the relevant to this book? What is there anything specific about privacy that makes it enter to למכלול השיקולים?
Yuval, can I begin as I instigated the follow-up? So thank you, Daphna. If you have more important matters than privacy to deal with, then it's okay. So you're absolutely correct that as a general matter, privacy is not the most important consideration in IHL, but we are actually dealing here with the introduction of new technologies which broaden the spectrum of tools which are used in order to engage in warfare. And of course, when I think of a tank or bombing from a plane, then privacy is not the most important element. But when we enter cyberspace, when we enter the realm of interconnecting between cybernetic tools and humans, then privacy emerges as a more important consideration, and it is of pertinent importance in relation to those technologies. So I think that that's the main explanation. But Yuval, if you want to.
Yeah, I mean, I would also say that, well, first, yes, I mean, this is a book about privacy, and privacy is an important human right. It's, and again, it's not covered by IHL by and large, so there is an additional dimension. But I think that what's interesting about these tools is that you can design them often in ways that would minimize their harm to privacy interests. Okay, so if we're talking about, for instance, the issue of retention that we talked about, I mean, this is an issue that the privacy harm is largely gratuitous. I mean, you don't need it for the, I mean, for there is no justification to, for instance, after the conflict, to retain the information, or like Thomas said, to not to keep it anonymized. So there would be aspects, or in terms of engaging in massive data links as a new form of psychological warfare. I mean, we've seen this actually now in the Ukrainian conflict, when the Ukrainian side has hacked into basically the files of all the Russian soldiers who have been sent to allegedly to the Ukraine, and they have published all their names. So all the names of the soldiers that are involved are now that's, I don't know, maybe it's fine. I guess I would imagine that this is part of legitimate psychological warfare, but maybe a strategy that would basically publish all the names and addresses of all Russian citizens, and then indicate which are soldiers. That would be something that would raise different issues. So I think we're seeing, like Tal said, with this new technological developments, we're seeing more and more issues where privacy questions are raised. And we need to come up with, we need to come up with certain approaches as to how to deal with them. So maybe I agree with you that that's not the most important issue on the battlefield. But we often work on issues which are important, but not the most important, and we leave the most important to other people. That's how.
For sure, and I agree, that it needs to be a consideration in light of new technologies. I'm just wondering, like, normatively, when we try and address new technologies and those new challenges, is there, like, normatively, is there any specific consideration that brought privacy to be here in the front and not something else, or is it just, like Tal said, that this is like the main concern that new technology poses? So
no, I think privacy is in the forefront of these technologies. I mean, there is a discussion about privacy concerning these technologies, regardless of the military context, okay? The question is whether this discussion is also valid in the military context. So hacking raises issues regardless about privacy. The question is now, when you're introducing it within a military context, is there a legal framework that one has to be thinking about? So it's not that that privacy was randomly raised. I mean, these new technologies, I mean, traditionally they've raised, mostly concerns about freedom of expression, privacy, and increasingly equality. I mean, these are like the main issues that have been raised. Okay, I think in terms of the interface with IHL, probably privacy is the more immediate concern out of the three in terms of what is the implication of these technology and what is the most immediate harm that they can cause. Okay, within this framework of harm that we have already discussed outside a military context.
Thank you.
Okay, תודה רבה.
אני חייב להודות, יובל, שהשאלות היו קשות יותר מאשר בכנס עם החברים שכתבו את הספר. זה היה מאוד מאתגר ומעניין. ואני הייתי צריך לפתוח עם זה, אבל לפחות עדיף מאוחר מאשר לעולם לא. נאמר ברוכה הבאה לנעמה דניאל, שהצטרפה אלינו כעמיתת מחקר, כרגע מסיאטל. נודה לדנה יפה על השידוך. אנחנו מחכים לעוד 2 עמיתי מחקר, ויש לך מקום בגן עדן, או עמיתות מחקר. המון בהצלחה, נעמה. אם את רוצה להציג את עצמך, את מוזמנת בחום לעשות את זה.
תודה רבה, אני מאוד שמחה להיות כאן. אני גם שמחה בכלל להצטרף למרכז, ושמחתי לראות כאן גם חברים ותיקים וגם קולגות ואולי חברים חדשים. ואני חייבת להגיד שההרצאה היום הייתה מאוד מעניינת בשבילי. אני באה מתחומים של קניין רוחני, עבדתי במשרד המשפטים 7 שנים, ואחר כך עברתי לכנסת, לייעוץ המשפטי של ועדת הכלכלה, שם עבדתי 4 שנים. אז בעולם שלי המלחמות האחרונות היו מלחמות הסטרימינג, בין נטפליקס, דיסני ואמזון. זה היה לי מאוד מעניין לשמוע את ההרצאה היום, ומאוד ככה פוקח עיניים. וזהו, אני ממש מחכה לעבוד עם כולכם, ולשמוע עוד הרצאות בנושאים חדשים. תודה רבה.
תודה רבה.
תודה נעמה, מצפים לשמוע על התכנים שלך, ואני מניח שדרפה צריכים עורכי דין לקניין רוחני, אז הנושאים כאלה רחוקים אחד מהשני. תודה רבה לכולם, ועד הפעם הבאה.
ביי ביי.